Hello, everybody. Thanks so much for coming today. My name is David Steib. I'm on the board of the Washington Council of Lawyers, which is sponsoring the event today. And I've been on the board for a couple of years now, and I wanted to just tell you a little, before we get started, I wanted to tell you a little bit about the council, just so that you know who's sponsoring this organization, and encourage you to join the council, because it's a really great organization. So the Washington Council of Lawyers is a voluntary bar association dedicated to the promotion of public interest law and pro bono work. And, in furtherance of that mission, the council does a whole bunch of stuff. Part of what we do is training. So there's like litigation skills training for public interest lawyers. We also have a component of community building, making sure that public interest lawyers and attorneys doing pro bono work are able to find each other and to, gain support from each other. So we have happy hours. We have a mentorship program, which is actually the first way that I got involved with the council. Right after I graduated from law school, I joined the mentorship program, and I had a mentor who was more experienced than I was in public interest law, and she was on the board of the Washington Council of Lawyers at the time, and she still is. So now we're on the board together. But that was a great experience. The other thing that we do is present programs, such as the program today. And I'm going to tell you guys a little bit about the upcoming programs that we have. And really, I feel like with that, it kind of speaks for itself. I think that if my job is to entice you to join the Washington Council of Lawyers, I think just by listing off some of our upcoming programs, I will have done my job. One program we have coming up on Tuesday is called Giving Teeth to the Language Access Act of 2004 in DC. And that's going to be a panel discussion with Council Member David Grosso, talking about the fact that although we have a local language access law in DC, it needs some improvements in order to actually be enforced. So that's going to be on June 20th at 5 p.m. And all of these events you can find on the website for the Washington Council of Lawyers. The other event that's coming up is Fellowships 101. That's something we do every summer. It's for law student interns in the DC area who want to learn more about postgraduate fellowships and perhaps how to apply for one. So that's a really popular event. It goes well every year. That's June 22nd at 6:30. The Supreme Court Term in Review, A View from the Press Gallery. That's an event that's been happening for several years now. It's on June 28th at 12 p.m. And it's a discussion by journalists about what they've seen in the Supreme Court this term. There's also a lunch with Judge Eric T. Washington, the Summer Forum, which will be on July 24th at 12 p.m. And the Summer Forum is an event that we do every year with summer associates from law firms and also with interns from public interest organizations. And it offers them a chance to come and hear some panel discussions about different areas of public interest law. And there's always a keynote. And this year, the keynote is Justice Ginsburg, which is very exciting. So anyway, that's some of the events coming up. I encourage you to join the council. If you join the council, you know, for instance, with the Justice Ginsburg event, you would have gotten priority to sign up for it and advance notice, and you would have paid less to attend the forum. Unfortunately, that event is sold out, but for future reference. And everybody should have a flyer on their desk that has information about the council, and on the back there's how much it costs to join, and you can always go to our website and click the join button. So I encourage you to do that. Without any further ado, I wanted to introduce our speakers today. We have Katie D'Adamo from the Public Defender Service. She's an immigration lawyer there. And Susannah Volpe, the Associate Director for the DC Immigration Program at Ayuda. So I will turn it over to them.
So thanks so much for coming. Thanks so much to the Washington Council of Lawyers, to Mayor Brown, and to our sponsors today. We were going to start just by telling you a little bit about the organizations that we're a part of and what we do, and then launch into the meat of the presentation. So starting Ayuda, Ayuda is a nonprofit here in DC. We have 3 offices, one in Tacoma, one in Falls Church, Virginia, and one in downtown DC. Our mission is to protect the rights of low-income immigrants who live in the metropolitan area of the District of Columbia. We offer legal and social multilingual services for low-income immigrants in the areas of immigration, personal advice, domestic violence, sexual assault, and protection against family violence, as well as the Community Legal Interpreter Bank and the Victim Services Legal Interpreter Bank, which provide interpretation in a multiplicity of languages, interpretation, translation, and in-person interpretation to DC nonprofits that provide legal services or work with victims.
And my name's Katie. I am the lone immigration attorney at the Public Defender Service of DC. The Public Defender Service represents indigent clients accused of crimes here in DC. We're not the only public defenders in DC. We primarily represent individuals accused of more serious felonies. Though that's not the rule. There is a bank of Court Justice Act appointed lawyers that also take cases on behalf of indigent clients. So my role is, among other things, to advise on the immigration consequences of criminal convictions for our non-citizen clients, both that of PDS and of the CJA panel, and help to work with those lawyers to seek, when appropriate, more immigration-friendly outcomes, and to advise the clients about what the risks of even engaging in the criminal justice system in DC may be. So we'll go into that in a bit more detail later. So today we plan to talk about, I'll give an overview of the DC criminal justice system actors and how each of those actors, what their current interaction is with immigration authorities to our knowledge, and also talk a bit about how the Department of Homeland Security's enforcement priorities have changed in the wake of the new administration. Thank you. So DC is very unique. Even though we have this sort of non-state colony-esque situation where we have DC-funded agencies that are subject to, for instance, the mayor's dictates, and then we have federal agencies that also make up the criminal justice system. So to break them down in terms of which players interact, the DC agencies include the Department of Corrections, or the DC Jail, the Metropolitan Police Department, the Office of Attorney General, which, as relevant to the criminal process, prosecutes typically misdemeanor and traffic offenses, the Department of Youth Rehabilitation Services, which is responsible for the juvenile court system, the juvenile justice system here in DC, and the Office of Victim Services. In terms of the federal agencies that operate in the DC courts, we have the U.S. Marshals. So the U.S. Marshal Service serve as the bailiffs and the security in the courthouse. They also do the transportation to and from the courthouse and the DC jail. CSOSA, Court Services, I should know this. Court Supervision, Offender Supervision Agency, is a federal agency that's responsible for overseeing individuals placed on probation in DC. The Pretrial Services Agency is a sort of subdivision of CSOSA that is also a federal agency. If an individual is released on their criminal case and ordered to report to pretrial services as a condition of their pretrial release, they would go to report to pretrial services. The Bureau of Prisons, where our clients who face significant incarceration as a result of conviction in their case, is where many of our clients would go. The Bureau of Prisons has prisons all around the country, and they are indeed a federal agency. And lastly, the U.S. Attorney's Office, which is the local prosecutor, essentially, in conjunction with the Office of Attorney General, is a federal agency. So this makes for a very unique setup here in D.C. I don't think there. Okay, great. So how do these different agencies interact in the criminal justice process here? So first, when an arrest occurs, you'll typically have the Metropolitan Police Department at the scene. The person, once they're arrested, depending on the offense, they could be given a citation or they can be booked and taken over, typically to the DC courthouse at a certain point for arraignment, meaning presentation before a judge, officially being told of the charges that they're facing, and a preliminary opportunity for a release determination by a judge. So there's a courtroom called C10 in the basement level of the DC Superior Court where that occurs. The actors in place there are pretrial services. So when an individual is arrested by the police department, pretrial services will then interview them once they get to the courthouse and ask them a series of questions, including questions about their national origin, which I'll get into in a little bit. The U.S. Marshal, again, is responsible for the security in that courtroom. And so in that courtroom, the judge makes a determination about whether the person will be released on their pending case or they'll be held because of the nature of the offense or other factors. It also may be that the person is ordered released on the DC criminal case, but then has a detainer, say a criminal detainer from another jurisdiction, in which case, so if someone is ordered released, they will step out of the back of the courthouse. So they'll basically be unshackled in front of the judge and walk out the back of the courtroom. If the marshals and pretrial services then determine, however, that they have a detainer, they will be then stepped back into the cell block by the U.S. Marshals and continue to be detained. And I'll get into this a little bit more specifically as it relates to immigration. In terms of the next steps, whether people are either released, if people are ordered held during their criminal case, they will be held at the DC jail or the CTF facility, which is in the process of being kind of unprivatized, if you will. There's basically two main jail facilities that are over near Stadium Armory, where individuals are held pre-trial, and then individuals who serve very short sentences serve their sentences. If there is a guilty finding or a plea, then if they plead guilty or are found guilty of a felony offense, CSOSA, this probation agency / supervision agency, steps in and typically does what's called a pre-sentence report for the judge, where they ask a series of questions of the individual about their background, including questions about national origin, immigration status, and all sorts of things. That goes to the judge and to the prosecutor. If the individual is placed on probation, they will be supervised, continue to be supervised by this federal agency called CSOSA. If they are ordered to more than typically 6 months, they may face doing their time at a Bureau of Prisons facility anywhere in the United States. And again, if the case is dismissed, typically people are either released from DC jail or have complied with their pretrial services. So just to get into a little bit more specifically how interaction with ICE can be triggered. Really in DC, because of this unique federal agency, DC agency interplay, interaction with ICE can be triggered at each stage of the criminal case. And for folks who don't know, ICE refers to Immigration and Customs Enforcement, or the enforcement arm of the immigration authorities. So in terms of the arrest stage, while there is currently a policy in place that the Metropolitan Police Department is not supposed to inquire about the national origin or citizenship status of individuals, they take fingerprints when they arrest someone. And those fingerprints are sent directly to the FBI and by extension are sent through various immigration-related databases. Namely, any database, it's called IDENT database, where individuals have had a prior, say, apprehension at the border, with Border Patrol, and they've had fingerprints taken. Individuals that have had visas granted, their fingerprints will be in. And so if there's an arrest that occurs, oftentimes once those fingerprints are sent through at the local level from the Metropolitan Police Department and then automatically sent to the FBI, a flag can pop up with the immigration authorities with respect to the fact that the arrest has occurred. In terms of the arraignment stage, as I mentioned before, pretrial services collects a series of information from the individual to present to the court. And typically this occurs before the lawyer can even get to talk to the client. And before a lawyer has even been assigned. So a pretrial services agent goes and talks to the individual that has been arrested, asks how long they've lived in DC, if they have children, if they work, and they ask where they were born and whether they're a U.S. citizen. And that information goes into a report that then goes to the judge. And if the person ends up being placed on probation, because they're essentially pretrial services and CSOSA are part of the same agency, that information is automatically shared with the probation agency. In our experience, pretrial services has cooperated with immigration authorities. And I will not say in every case, but we've had clients who have been picked up while they were reporting to pretrial services. here in DC. The U.S. Marshal is, as I mentioned before, it's serving as the bailiff. So when you have this first stage of arrest, say the individual is charged with maybe a misdemeanor offense, a public intoxication or something to that effect, they will then, their policy is to comply with ICE detainers, I should say. Do folks know what ICE detainers are? I guess I'll explain. So an immigration detainer is really a request. It's a request from Immigration and Customs Enforcement that the law enforcement agency that has custody of the individual first notify the ICE when that person will be released from that agency's custody, and two, that they maintain custody of that individual for up to 48 hours for ICE to come and apprehend them. The current policy, as we understand it, of the U.S. Marshal is that they will only hold the person until the end of that business day, but they will comply with ICE detainers, and even in some cases where there's been communication with ICE and they don't have an ICE detainer in hand, that they will even comply in other circumstances when they understand that there might be a request by ICE to pursue this individual. Backing up, so pretrial runs when an individual is arrested. Pretrial does basically an FBI background check through the NCIC system, the National Criminal Information Center database, and runs a report on every individual that's arrested in DC. And so that report is accessible to both the U.S. Marshals and to pretrial services. Now, NCIC is supposed to just be for criminal background, criminal issues. However, they're often, if an individual has a prior deportation order or has had a prior apprehension by Border Patrol, that information is in the NCI system. And so when that happens, it's unclear whether ICE is reaching out to the Marshals or whether the Marshals are reaching out to ICE. But what I can say is that ICE frequently does issue detainers for individuals who are coming through C-10, and the Marshals have confirmed that sometimes even when they don't yet have a detainer, they will hold people even if they've been ordered released on their charge for ICE to potentially come and pick them up. The next stage, so if someone is ordered, well, just to explain how this works. So go up, judge says you're ordered released, and instead of that person being unshackled, it's then that the Marshals will say ICE hold and step them back to go back into the cell block. If an individual is arrested and ordered to be held at arraignment, they will typically then go to the DC jail while they'll wait for their next court date, which is usually set 3 days to a week out from that point. At that point, the DC jail is then responsible for custody. And the DC jail currently does accept ICE detainers, and my understanding, at least as of a month ago, was that they notify ICE for the release of anyone for whom an ICE detainer is lodged with them. So folks may be aware there was some strong advocacy years back that resulted in the passage of a law, the DC Code 24-211.07. And that law, I'll get into specifics, but it made it so that the DC jail or any sort of DC related criminal agency that had custody could only comply with ICE detainers and hold someone if the individual for whom the detainer was filed had certain convictions. So either had been convicted of a crime of violence or a dangerous crime as defined under the DC Code within the last 10 years, or a similar conviction. I have the language up in a subsequent slide. However, it's the DC jail's position, at least as of a month ago, that the notification about the release does not run afoul, that is not covered by that DC code. So that code only specifically refers to holding. So it is their current policy to notify of a release for anyone with an ICE detainer. So we've had people who've been ordered released who have been apprehended either right outside the jail or sometimes inside the jail prior to actually exiting. If somebody is ordered to, or if somebody takes a plea or is found guilty, as I mentioned before, if they're sentenced to probation, then they'll be supervised by CSOSA. For any felony conviction, CSOSA also performs a right to pre-sentence report. where there are very detailed questions asked about many aspects of the individual's life, but most notably where they're from, what their immigration status is, when they came here. There are often questions, depending on who the pre-sentence writer is, about family members and where they might be, very detailed questions about where the individual went to school, and many times if that is outside of the country, then they would answer those related questions. It is CSOSA's policy to report every suspected non-citizen to ICE. So that is the policy on the books. We have seen that happen sometimes even before an interview is conducted, when the case has just been assigned to a pre-sentence report writer, and there has not been an interview that has taken place. So again, if the individual is sentenced to probation, they are supervised by CSOSA. CSOSA has a policy of cooperating with ICE, and there have been individuals who've been apprehended while reporting to their probation appointments, or through other sorts of communication while on supervision. The Bureau of Prisons, if individuals are sentenced to prison time, also cooperate with ICE. They both release people to ICE who have detainers and will hold for individuals with detainers as well. So I'll go into a bit of the policies, a bit more detail. So this may seem strange because we've heard that DC is a sanctuary city, and Mayor Bowser has confirmed that on a number of different occasions. However, Mayor Bowser's edicts arguably do not cover the operations of these federal agencies that operate within DC. So the mayor's order, predates Mayor Bowser, but that was issued in 2011. It's Mayor's Order 2011-174. Specifically goes through the public safety agencies that it applies to, and that's listed in that previous slide. Going back. So the DC Jail, Metropolitan Police Department, Office of Attorney General, Department of Youth Rehabilitation Services, and Office of Victim Services. So pursuant to this mayor's order, which has been confirmed as still in effect, they shall not inquire about a person's immigration status or contact ICE for the purpose of initiating removal proceedings. They cannot detain on the basis of a civil immigration violation, meaning it can't detain based on suspecting that the person's here in the country unlawfully. They can't make an arrest based on these NCIC hits, which suggest that the person might have had a prior removal or an administrative warrant of deportation issued by an ICE officer. And it requires that there be a policy in place to ensure detainees are not made available for immigration interviews without a criminal nexus, which is sort of more detailed. So currently, that's the understanding that we have, that the Metropolitan Police Department should follow those orders. I have had anecdotally reported to me that there have been officers who do ask questions about country of origin. It's unclear where that information goes, if not in the police report. In moving on from those other agencies, so going to the federal agencies, the U.S. Marshals, again, their current policy is to comply with ICE detainers and in select circumstances hold until ICE comes, even without a detainer in place. And just for background, there's been a lot of litigation nationally about whether a detainer passes Fourth Amendment muster to justify a law enforcement agency holding someone, because civil immigration violations are civil issues, right? They are not criminal issues. And so the ACLU has successfully litigated in other places to show that, say, a state police, they do not have probable cause to continue holding someone based on this immigration detainer, which is really just a piece of paper signed by a deportation officer, when there's no independent probable cause established to continue to hold that person for a violation of a criminal law. Interestingly, again, we're dealing with the U.S. Marshal Service, which is a federal agency. So the legal analysis is a little bit different, maybe outside the scope here. Again, DC Jail, their policy is they don't hold for ICE, that they process a person for the ordinary, for release as they ordinarily would. I would say DC Jail's policy is to release individuals by 10 p.m. the day that they're ordered released. So practically what happens is somebody could be in court at 10 a.m., their case is dismissed, they're ordered released. everybody has to go back to the DC jail, even if you're ordered released that day, to be processed. And so at that point, if an individual has an ICE detainer, that's why we see apprehensions happening outside of the DC jail and not at the courthouse per se, because they're actually processed out through every single person that's released is after that first day. So if you're not released out of C10, the arraignment court, you're released out of the DC jail. Let's see. And here's just the detainer law for you all. I'm sure this will be emailed out to you, but it describes a little bit more specifically the pre-requirements that for the DC jail to hold an individual pursuant to an ICE detainer. And again, the specific language is the District of Columbia is authorized to comply with civil detainer requests from ICE by holding inmates for an additional 24-hour period after they would have otherwise be released only if, and then these various caveats. However, as I stated, it's the DC jail's position that they're processing pursuant to the ordinary course of release, but they will notify ICE as soon as they know about the release. And so if ICE happens to be there or come when that person is released, so be it. Practically speaking, a lot of our clients, even if they're ordered released at 10 a.m., often don't get released until 10 p.m., 9 p.m. So there's quite a significant delay caused by this processing. I think I've already covered most of this. The last thing I'll note is the U.S. Attorney's Office. So as folks know, the head of the U.S. Attorney's Office is Jeff Sessions. He issued a memo back in April directing the U.S. attorneys to prioritize prosecuting federal immigration-related crimes. Specifically, the April memo directs U.S. attorneys' offices to increase your efforts making the following immigration offenses higher priorities. So several code provisions listed. 8 U.S.C. 1324, bringing in and harboring aliens. 8 U.S.C. 1325, improper entry. So it is actually a criminal offense to unlawfully enter the United States without permission. It's a misdemeanor. I think it carries up to 6 months. 8 U.S.C., there's no statute of limitations either. So somebody that unlawfully entered without permission 20 years ago could still be prosecuted for this offense. 8 U.S.C. 1326 is illegal reentry. So somebody that's been deported before and returns and is found back in the United States can face prosecution for illegally reentering after deportation. 8 U.S.C. 1546, individuals that have committed fraud or misuse of visas, immigration-related fraud, and a couple other provisions, aggravated identity theft being one of them. So this makes it challenging in terms of representing clients when we have clients who are non-citizens and a decision has to be made about whether we're going to raise immigration issues in an attempt to negotiate for an alternative offense. And it's quite a difficult decision for clients to make when the entity you're dealing with is the U.S. Attorney's Office that has been directed to more aggressively prosecute immigration-related crimes for which your client may have liability. The last thing I wanted to talk about is the enforcement priorities. So as folks you're all here, so you've all probably heard about the way that immigration enforcement has changed pretty dramatically in the last few months since President Trump came into office. He issued an executive order on interior enforcement within the first week of his presidency and later issued an implementing memorandum explaining what that meant. And so while the memo mentions that they're going to specifically focus on certain removable individuals who are priorities, it's been also made clear through statements from the Department of Homeland Security and the plain language of those documents that really anybody who's removable, anybody who is undocumented, is fair game for immigration enforcement. However, the specific priorities listed by the administration include anybody who has a pending criminal charge, even if they have no conviction, but they simply have a pending criminal charge, anyone who has a criminal conviction, and both of these include criminal traffic. So driving without a license in Maryland, for instance, or traffic-related criminal offenses would be make somebody a priority, even just having a pending case for one of those. Individuals who have committed acts that constitute a chargeable criminal offense. So this one is very broad. And this is in the eyes of the immigration officer. So anybody that's committed acts that constitute a chargeable criminal offense could be prioritized. That includes people who've unlawfully entered the United States, right? Because they could potentially be charged with that federal crime I spoke about. Anyone who's engaged in fraud or willful misrepresentation, anyone who's abused programs related to public benefits, anyone who's received a final order of deportation but have not actually left the country, or anyone who's otherwise deemed to pose a risk to public or national safety in the judgment of an immigration officer. So we have that catch-all in case you're not captured in any of those others. And so really any individual, Susannah and I were remarking about this. In the course of my work over the years, I've certainly had individuals who, even prior to this job, who have at one time been, victimized and at another point are accused of a crime, right? And here, given the new enforcement priorities, because of the way these agencies in DC interlap, there is significant risk to people on both sides of that aisle. And I'll turn it over to Susannah.
Yeah, I think that's absolutely true. And so following on that, we're going to sort of move from the criminal court system into the ways in which people who are or have been victims of crime interact with the courts in DC and primarily in the civil system. Thank you. Starting first talking about the DC civil court actors, and then thinking about legal protections for victims and statutory protections that are in place, and then finally coming to DHS enforcement practices. So mirroring what Katie has talked about from the civil side of things. So just taking a CPO process, for instance, Katie explained all of the different and intersecting agencies that are part of a criminal charge all the way to a possible criminal conviction or dismissal of criminal charges. The CPO process is the civil side of interacting with courts. There are, of course, many different civil actions that one could take, but as an advocate for victims, CPOs are frequently a way in which our clients begin to interface with the DC court systems. And I've color-coded this because I think it's a really visual image of how intersecting DC nonprofit and federal agencies are within the civil court system. So starting with the incidents in which a CPO qualifying incident occurs, so MPD may be at the scene. You may also have OCAP, or SAFE, involved and called at the scene. CSOSA may be involved, as Katie said. They're federal. DCPS, DBH, this should be the Department of Behavioral Health. These are all agencies that may be involved in this interaction. Then an individual who wants to file a CPO can file a petition, at which point they come to the court and they interact with the DBIC, which is SAFE, an NGO. OAG is actually the reception at the SAFE Center. Then you have the option of reaching out to MPD, to the USAO, to DBH, to DCPS, to CSOSA, depending on a lethality assessment. You then have to interact with the DCDB clerk, who is a federal agency because they're the clerk at the DC court. Service on the opposing party is done by MPD, a DC agency. The hearing involves the judge, the CSO, the court supervision officer, and the U.S. Marshals, who are federal. And then finally, ongoing enforcement of the CPO involves federal and DC actors. So this is all to say that when advising clients in these situations, it's important to be clear about the different actors with whom a client may come into contact. And thinking about opportunities for advocacy, because many of us in the room are advocates in these situations, it's also interesting to think about all these actors as how we as advocates can help our clients' interactions with the agencies result in positive outcomes for our clients. So something that we see a lot of it at Ayuda are U-visas, and thinking about U-visa certifiers. So a U-visa requires that a client be a victim of a specific qualifying crime, that the client assist in the investigation, prosecution of said crime, and be a victim of or have suffered substantial harm. And the certifying agencies in this picture, one should always be thinking about certifying agencies as your client is interacting with these different actors. I put in here that something important that judges, so certifying agencies will have a certifying official, so a specific individual within the certifying agency who signs a U visa certification. Judges do not need to be designated. So any judge who is part of the investigation or prosecution of a qualifying crime or criminal activity is able to sign a U visa certification. And keep that in mind as your clients are going through this process about ways in which we can advocate on behalf of clients. Another important element is thinking about how there may be opportunities during this process to help your client obtain documentation that may be required at a later phase or may assist. So thinking about discovery and what sorts of documents clients may need, proof of citizenship of an aggressor, proof of police reports, documentation of injury, that sort of thing can all be elements that we as advocates think about obtaining for our clients during their various interactions with these agencies. Moving to protections for victims. The two statutes that I want to talk about today are the VAWA confidentiality statute, which is 8 U.S.C. 1367, and the statute governing the initiation of removal proceedings, which is 8 U.S.C. 1229, and I actually think it's 1229E. So the 8 U.S.C. 1367 protects the ways in which immigration enforcement, so ICE and DHS, can act on information from potential aggressors. And the point of this is to ensure that DHS doesn't continue and continue to operate on or to use the power and control that is part of the cycle of domestic violence to further victimize somebody who may be an immigrant. So I'm just going to read through this because I think it's helpful, but I think the visual is actually the way to think about sort of who is protected and who can't provide information. So in no case may the Attorney General make an adverse determination of admissibility or deportability of an alien using information furnished solely by a spouse or parent who has battered the individual, a member of the spouse or parent's family residing in the same household, a spouse or parent who has battered the individual's child, or a member of the spouse or parent's family residing in the same household who has battered the individual's child. So looking at this graphic, the protected people are the immigrant adult who is a victim of battery or extreme cruelty, the child of the immigrant who is a victim of battery or extreme cruelty, and the people from whom information cannot be solely obtained are the parent, spouse, or household member of those two protected individuals. And I say two, of course, we can have multiple individuals and families and there's sort of bigger, but these are the relationships that trigger 1367 protections. The other important protection under this statute is in no case may the Attorney General, again, make an adverse determination of admissibility or deportability using information furnished solely by, in the case of an alien applying for U visa status, the perpetrator of the physical or mental abuse and criminal activity, or in the case of someone applying for T visa status, the trafficker or perpetrator. And without going deep into immigration law, U visas are for victims of certain qualifying crimes. T visas are for victims of trafficking. That can be labor trafficking, that can be sex trafficking, that can be various forms of trafficking. But this is to say that the person who commits a criminal offense or a criminal activity against an immigrant who will apply for status based upon having survived that particular offense cannot be the person who provides information to DHS that allows DHS to enforce immigration policies or continue enforcement actions against that immigrant. It's really important to know from this statute that applying for is more than just filing your application. And that's an important advocacy moment for all of us to think about. How do we ensure that the people we interact with, if they might apply for these actions, begin the process of applying for? What does that mean? That means maybe a letter from an advocate saying this person is eligible for said visa. That means perhaps information that an applicant is going to come to your office to be assessed for eligibility. Think also about providing the applicant reports of the victimization that's gone on, evidence to show that they would qualify for these visas may be sufficient to trigger this applying for protection. So this is just briefly to tell you the protected application types under the 1367 statute. An I-360 is a VAWA self-petition. The 914 is for a T visa. The 918 is for a U visa. The 751 is the battered spouse waiver. And I provide this just to show how broad the statute can be, that there are a wide variety of applications that are protected under here, and any evidence of having filed or being in the process of applying for these applications should be reasons to prevent DHS action on information provided solely by a perpetrator. What information is protected? Address and contact information of a potential applicant, records that are not necessarily related to the abuse. So if they're records, for instance, of prior apprehensions that may not be related to the abuse, that information is protected and can't be disclosed under the statute. So the other element of 1367 is not solely governing DHS actions and enforcement actions, it's governing DHS ability to share information and what can be provided from DHS to other agencies. So DHS can't provide other agencies information on the existence or non-existence of an application for relief under those specific types of forms that we just looked at. And it also can provide information on information not yet databased is how it's sort of understood within DHS, but meaning information that an officer may have that is not yet part of the internal electronic systems. There are limited disclosure exceptions. Without going deep into them, they involve census information, so information that's de-identified for census purposes, information for congressional oversight committees, again, de-identified, and then certainly Katie will be able to sort of answer questions about this as they come up, but information that may be required to be presented to a judge to determine whether through judicial review the information is protected. So thinking about Brady material and what may be protected in those situations. So how is this triggered? DHS needs to have a reason to believe that the individual is a victim of qualifying abuse. The reason to believe, so again, this is going back to how do you ensure your client is protected and can trigger this protection. Think about providing letters regarding eligibility. Think about filing applications quickly. Of course, get your cases approved if you can as quickly as possible. And lastly, it's important to remember that these are statutory protections. So violation of these protections involves individual fines. So to individual officers and individual agents can be personally fined. And there's statutory remedies for these violations. And I think that's important in this current moment in time because we're seeing a lot of changes happening through policy and through practice, but this is a law that has not changed and that remains the same and that we as advocates should be aware of and should be making sure that we move to ensure the law is enforced. Again, the protections end only when the application is denied and all opportunities for appeal are exhausted. And so if an application becomes moot because the client applies for another form of relief, the protections go on. And so it is only upon denial that the protections will no longer apply to this client. And again, certain applicants with certain criminal convictions, and those are convictions listed under INA 237A2, those applicants aren't protected by this statute, but the message I think needs to be for all of us who work with clients is that if you have a client who has been victimized and who also may have pending criminal charges or may have criminal convictions, you really need to make sure that they consult with an immigration attorney who knows their way through this statute to be able to get the information they need. So the other law that I want to talk about is the 8 U.S.C. 1229E, which is sensitive location enforcement. This law says that where an enforcement action leading to a removal proceeding was taken against an alien at the locations below, the notice to appear, which is the charging document in immigration court, shall include a statement that 8 U.S.C. 1367 has been complied with. So that's all of the protections that we just discussed, ensuring that DHS does not initiate enforcement actions based upon information from a perpetrator of violence. If an enforcement action happened, DHS has to say that the enforcement action at these specific locations did not arise based on information from a perpetrator. So the first part of the statute deals with domestic violence shelters, rape crisis centers, supervised visitation center. So we saw that in our image of the courts, the court supervised visitation center, family justice center, victim services or victim services provider, or community-based organization. And it's interesting, in Title 8 of the U.S. Code, these spaces are not defined. And I actually think that works to our advantage as advocates, because we have a lot of room to advocate about definitions of what these organizations are. So keeping that in mind, many of us perhaps work at or are interns at organizations that would fall within these criteria. And we should be thinking about 1367 if, hopefully not, DHS ever shows up at our agencies, and how we can use the laws that exist to protect our clients and our potential clients. The other element of Part 1, so Part A of this statute, is that if there is an enforcement action at any of these locations, and you want to invoke the 1367 protections, there's no need to show that your particular client, who's the target of the enforcement action, was or will be applying for status based upon victimization. So it's just at these locations, information leading to the enforcement action cannot have been provided by specific perpetrators of violence or abuse. And it doesn't matter whether the person who was picked up is going to apply for status based upon having been the victim of certain violence or crimes. The next part of this statute deals with enforcement actions at courts. And so an enforcement action at a courthouse needs to be in compliance with 1367 if the person who is the target of the enforcement action is appearing in a protection order case, a child custody case, or a civil or criminal case relating to domestic violence, sexual assault, trafficking, or stalking, in which the alien has been battered or subject to extreme cruelty or forming the basis of a U or T visa application. And again, I think that the point that Katie made, that many of us have clients who may have appeared in both of these systems, is important here, because there are waivers within immigration law for people who have perhaps committed acts of violence but are actually primary victims of violence. So we often see, unfortunately, we often see that, let's say in a domestic assault situation, we see both people involved be arrested by police. And it's important to keep in mind that when appearing in relation to these cases, we need to be thinking about how we protect our clients who may, in fact, have cross CPOs pending or be charged with actions based upon also being victims of certain actions. So what's the triggering mechanism here? The triggering mechanism here comes into force at the time when the client first appears before an immigration judge on the charges. So as a practice tip, we should try to get into those situations to prevent the charges from being filed at court, right? And so how do we do that? We should think about preventing the filing of charges, interceding with ICE, and I think this is a lot about thinking about our allies and our connections and relationships within the communities in which our clients live and within the agencies that our clients interact with, whether there are ways that we can prevent charges from being filed simply by bringing to the attention of particular officers who may be filing those charges the need for compliance with 1367. And then if, in fact, one does get to immigration court based upon charges, we should be moving vigorously to terminate proceedings based upon failure to comply with 1229 if that is indeed the case. And again, this is a situation where I think both of us would be happy to talk more about how the immigration court remedies might be applied for clients, but it is important for all of us, whether or not you're immigration lawyers, to be thinking about this and to be aware of the fact that there are moments of intercession prior to court, but the first time when statutorily there is a requirement to comply with this law is when appearing before the immigration judge. Again, these protections in certain cases that you saw will apply whether or not the immigrant is applying for status based upon victimization. And also keep in mind, again, this is a statutory protection, and we have the Office of Civil Rights and Civil Liberties, who is equipped to investigate complaints, investigate violations of this statute. And I put in the PowerPoint, which I think everyone's going to get a copy of, a link to the complaint form. And so violations, we can be reporting these, and they will be investigated. So the next enforcement related element that I want to talk about is the DHS's Sensitive Places memo. It's a 2011 memo that was a carve out in the recent executive orders, and it has been stated that this memo remains in effect. And so this memo protects enforcement actions at particular locations. The locations are schools, and that's from daycare through universities, right? That includes school-related activities, and even going so far as bus stops where kids wait to get on the bus to go to school, right? Medical facilities, hospitals, clinics, doctors' offices, emergent and urgent care facilities, accredited hospitals, so facilities that provide medical services, not just the ones that say hospital out front. Places of worship. This is even extends to situations where a building that has that is not specifically designated as a place of worship is rented by or used by a religious congregation for religious activities. Religious and civil ceremonies, funerals, weddings, other observances, and then public demonstrations, so marches, rallies, parades. I just put on the bottom, this doesn't include courts, and that's important for us to be aware of, that the way in which enforcement happens at courts is different. In this memo, there is an additional admonition that ICE, so DHS, when engaging in enforcement activities, needs to exercise particular care in places that involve children, pregnant women, victims of crime or abuse, or people with mental or physical disabilities. And that is, again, a tool that we should be implementing in a way that we can be protecting our clients. I've had people ask and sort of think about, well, if the school is here, does it apply to the parking lot? Does it apply to the other side of the street? What is actually the geographic space protected? There's some language in the memo that talks about at or near sensitive locations. And I think that's our opportunity to say at or near means at or near. And that we need to take that language seriously and say it's not just within the four walls of this building, it's within the vicinity, it's within the area in which activities at this building are happening. Again, there are exceptions to this, and the exceptions include enforcement activities if they're exigent circumstances. DHS has defined exigent circumstances to mean a risk to public safety, a risk that evidence will be destroyed, a national security or terrorism risk, or if pursuing someone who presents a danger to others. Again, another exception is if it's the result of other law enforcement activities, if there's prior supervisory approval, or if it's a border-related enforcement activity. We're not near a border here, so I'm not going to jump into that, but that has to do with some changes in the way DHS interprets this memo to apply when in the vicinity of a U.S. land border. And then the prohibited actions include any interviewing of people, any arrests, searches, or immigration-related surveillance, right? The actions that are exempted from this are service of subpoenas, guarding detainees, reviewing visa compliance. And I think that's an interesting one because when you think about schools and when you think about international students, DHS is permitted to review visa compliance at schools. And it's just interesting that there's still sort of inroads into these facilities despite these prohibitions against actions. But it's important that if DHS is in a school to review visa compliance, that they are only doing that and they're not interviewing or engaging in other surveillance activities. And the memo also requires annual training. So DHS employees should all be aware of this and should all be being trained annually on these issues so that they're not in violation of this particular memo. The other memo I want to talk about much more briefly is called the Victim Witness Memo, also from 2011. We believe that this is still in effect, and the memo is a policy against initiating removal proceedings against victims or witnesses to a crime, and against removing individuals as they are in the process of protecting their rights, their civil rights and their rights as victims of crimes too. Again, this memo requires particular attention to victims of domestic violence, human trafficking, or other crimes, witnesses involved in pending criminal investigations, plaintiffs in non-frivolous lawsuits regarding criminal or civil rights or liberties violations, and those engaging in a protected activity related to civil or other rights. This one is absolutely a tool that we as advocates should be thinking about, but at this point, it's not clear the ways in which we can bring this memo to bear quite as forcefully in our interactions with ICE and our clients. So that's all I have. We have space and time for questions if people have questions for either of us. Can you walk up to the microphone and then do your question? Okay. That'd be great.
Hello, I'm not sure if it's on. Hello. I was wondering what the level of danger is for out-of-status individuals who are party to a civil case, but they're not the victim of a qualifying crime for a U or a T visa.
So I can take a stab and then pass it on. I think sort of putting together the pieces of the new enforcement priorities that Katie talked about that say that have priorities, but the blanket priority is everyone who's not in status, right? And then taking into account the ways in which that individual may be apprehended or places in which that individual may be apprehended, and thinking about sensitive locations and whether there are ways to invoke protections around sensitive locations that don't require that the individual be a victim of abuse. So thinking about the locations listed in Part A. So domestic violence shelter, rape crisis center, supervised visitation center, family justice center, victim services, or community-based organization. I think there is a good argument to say that enforcement actions at those locations cannot occur based on prohibited information or obtaining information solely from prohibited sources, and that there's a statutory protection for the people that you may be thinking about. So people who are witnesses in civil proceedings that don't necessarily have to do with abuse, if I'm understanding your question correctly. I do think that those people may otherwise be enforcement priorities.
Yes, and I think to the extent that they're in a landlord-tenant case or something, and the issue of immigration status is being raised on the record at all, I think there's risk in airing that in open court, period. And then if there are marshals or other staff that aren't necessarily bound by the mayor's order, then, it's fair game. I haven't heard of any apprehensions, but, it's a mixed environment.
Hi. Question about the, you said that if it's a felony crime, then CSOSA would do this interview and ask all these questions about where you went to school or where you're from or all this kind of stuff. Do the person being questioned, do they have to answer those questions?
They don't. They have the option to decline to answer on advice of counsel. The issue
have they necessarily seen counsel at that point?
At the point where CSOSA is doing the pre-sentence interview, yes, they should have a lawyer, and that's part of the counsel, I think, to the client about whether or not to answer these. If you don't answer those questions, this this investigator is writing a report to the court about the person's background. And sort of depending on the judge, some judges put more stock into those reports. And so they may be troubled by the lack of detail, about certain critical pieces of information. Certainly I think that the lawyer can elect in that case to present the information in a more protected way, say filing something under seal or raising issues at the bench that pertain to mitigation or, sort of supplementing that report. The problem practically that we see is that because of that initial pretrial interview where people are asked about their country of origin and they're asked whether they're a U.S. citizen, that's done at that point. And that goes to that pre-sentence interviewer. And like I said, we have seen cases where there has been no additional communication, and literally the first contact after being assigned a case to investigate before talking to that person is to contact ICE to verify immigration status or to report the person to ICE. And so even at the point where you're getting to the interview, the damage may already be done. That contact may already have happened.
And I got a little bit confused about when you were running through the different actors and like when a detainer would be like, in effect, or when it would be when they would comply with the detainer and when they wouldn't.
Right.
And then you brought up the whole whether that's a violation of Fourth Amendment rights or whatever. Are there instances in DC where someone doesn't have like a special like criminal background or whatever, and they're going to be detained for 48 hours just because ICE wants them to be?
Currently, that is not my understanding. So, to the extent anyone is complying with a NICE detainer, and that would only be the two agencies really that are have custody of the person at any point during this process. So the U.S. Marshals or the D.C. jail, right? The U.S. Marshals policy is if they have the detainer document, they will step the person back if they're ordered released and hold them until the end of the business day. I don't know what that is.
Regardless of whether there's special reason to do that.
Correct.
Okay.
So even if the person has never been deported before, has been here for 14 years, has a family, is facing a very minor misdemeanor offense, even in those cases. In the DC jail, again, my understanding, they're not really holding them past when they should be released, but they have that buffer time built in. Their policy for generalized release is you must release somebody ordered release that day by 10 p.m. And so there's that sort of lag time.
In the first instance with the Marshals, is there an argument being made by advocates nationally that that's a violation of Fourth Amendment rights?
I think people are looking at it. But the Marshals are an interesting agency. They have some powers. You need to look at sort of their authorizing statute. They have some powers to effectuate civil warrants, but typically that is in the context of a case, something signed by a judge. The difference with an immigration detainer form is it is signed by a deportation officer or a supervisory deportation officer. There's not a judicial officer that's making a determination that there's probable cause to detain.
Does the judge get confused when they say, take the shackles off, the person will leave through the back of the courtroom, and the Marshals are like, oh no, they won't? Like, what is the judge?
Currently, it's an understanding that there's a deference, that this is a Marshal issue, this is a detainer issue, just like any other. And so this is what's going to happen, and that they don't have power to intercede.
Hi, this is in relation to the DHS enforcement memo. So you mentioned that that within the nearby vicinity of like religious institutions or places like that, they're not allowed to detain folks. But in Alexandria, there was recently a religious shelter where that occurred. So I guess now the question, for example, some service organizations in the area provide services where folks line up either on the street, like on the sidewalk. So is there an actual distance that has been determined? Is a sidewalk considered public and therefore up for grabs? Or like you mentioned, is it the parking lot? How far is the actual distance? And does it only pertain to religious institutions, or does it also pertain to, like, for example, schools or bus stops? Or
I think that's a really excellent question, and obviously is something that we need to be thinking about. I would love to visit with you further after this event to discuss that further. I think that might be something that we should think about advocacy around.
All right. Well, thank you all so much. We'll be around if people have additional questions.
Thanks a lot.